Revitalize the image of your practice with marketing and communication services from the Chester Company. We specialize in helping you communicate effectively with your patients. Whether it's a patient handout that announces a new service or a new website where your patients can conveniently make their own appointments, the Chester Company is here to help you present your practice and its services in the best light possible. Let us show you how. Call for a free, no-obligation consultation. 860-526-9903. 860-526-9903. Call now.
And we're back here on the Healthcare Business Network. I'm here with our guest expert this week, Dennis Melamed. And just to remind everybody, we're at hbnradioshow.com on the internet. That's hbnradioshow.com. Okay, Dennis. So what have you seen? I mean, you've been following this now for, 7-8 years since HIPAA came out. How have you seen the attitude of Office of Civil Rights? Have you seen them as overly aggressive or moderate in approach, or have you seen that vary depending on which administration, whether it was the Bush administration in power or the Obama administration? How would you characterize the Office of Civil Rights?
Well, I've been covering this actually, and I hate to say it, more like 15
Wow.
years. I started when I was a baby. The Office for Civil Rights has been very clear that they had no intention of slamming the industry, and for the first 5 or 6 years, they've been taking an educational approach to all of this. And in fact, it was some privacy and security officials within healthcare who were wondering when they were going to be more aggressive. Certainly, some privacy advocates and proponents were a little disappointed. But privacy and security compliance folks were waiting for some big shoe to drop so they could make a case for budgets. But they never were going to do that. I'm not so sure we really wanted anybody to do that. And the way I usually explain that is, if you think about what we're trying to do here with a HIPAA privacy rule, a medical privacy rule, we're trying to govern the most common conversation we have as human beings, which is, how are you? And within a healthcare setting, that is really the lifeblood. It is the major asset. What they were looking for was getting your systems under control in a reasonable way. It's one of the reasons why the rule, the HIPAA privacy rule, occupied 500,000 words, trying to cover a lot of different bases. And the problem has been the discretion, actually the flexibility they tried to put into HIPAA, because a lot of people got nervous. Can we share the data? Can we not share the data? And a lot of the obstacles, a lot of the challenges that we see are inherently conservative interpretations, and some of them misinterpretations of the HIPAA privacy rule that have led to some of the problems. Not OCR's aggression. Frankly, the thing that's most interesting is the recent breach notification rule is a form of self-executing enforcement. You have to report it. And if you report it, you've essentially told on yourself in one fashion or another that you've probably committed a HIPAA violation, and at the very least, you've gone ahead and had a breach. So as a result, the industry is doing a lot of OCR's work for it, because the big crunch is how expensive sometimes these breaches can be. They can run into the millions of dollars. Not all of them do, and I think some folks are overblowing, what it costs. But it is still going to be pricey for everyone, and so they don't need to be aggressive. And in fact, they've gone out of their way not to, because from a legal perspective, if they go really slamming people, they run into a whole other set of policy issues that will make their lives even harder and not necessarily increase privacy and security of health data.
Well, and also at the same time, they're making a tremendous push, the federal government, to encourage electronic medical records.
Right, and what you've seen there is been the Office of the National Coordinator for Health Information Technology, along with CMS, last summer come out with what their technical standards were for this, and they came out with a position of a very interesting one, and it was more from a security perspective. What they said is, if you're going to have an EHR system that's going to meet our meaningful use requirements, so you can get some incentive payment for adopting them, they left the security standards broad, because under the HIPAA security rule, you have essentially two types of requirements. mandatory. You have to do something, like you have to conduct a risk assessment. And some things were addressable, which meant that the healthcare provider or the covered entity could decide whether this made sense for them to do. Do I need to have some policy in place to lock a window in a room that has no windows? All right, that kind of thing, and some other things that gave them that. So there was some discussion that, why don't you adopt those kinds of things within the technical standards of the EHR? And ONC and CMS came back and said, no, we need to leave this open because you may need to do it. And if we play with the basic standards of an EHR, we don't want to foreclose in any way, shape, or form the requirement or necessity for security. So in many ways, these technical standards that have been created for EHRs have set the baseline for basic security and, in some fashion, privacy, because privacy does not match up entirely well with security because, as I say, privacy talks about use. It talks about sharing information. Security talks to protecting the integrity of it. These EHR technical standards have gone a long way to placing a good framework for ensuring the security of these medical records.
Question about insurance for privacy breaches. I've gotten a number of questions about this from listeners. Is there insurance that you can go out now and get to ensure this type of potential liability for the future if there's a privacy breach in your office?
Yeah, there are policies, but they can be pretty hefty. One of the things everyone should recognize is your general business insurance policy is not going to cover you for breach. So if you lose a laptop, like it's happened in 127 instances,
right.
Or more, 62 instances out of the 225, your typical business insurance will replace the laptop, but it's not going to do anything to cover you for the breach that occurred because of the data on the laptop. And they tend to be very high deductibles. And if you want, frankly, if you want to go down that road with insurance, Ron, if you see the kinds of things they require you to show, you are these are the other unofficial enforcers of the HIPAA privacy and security rules. The checklists and things and the attestations they want to see track very, very closely what the regulations require. And again, you're going to have high deductibles, and whether it makes sense to you is going to really have to depend on how big an organization you are, and really have to take a close look at what risk exposure you have.
So it's something that you can definitely see large organizations like hospitals doing, health systems.
Yes, absolutely, but it's not going to be cheap.